Welcome back to the Kelly and Kelly Law Podcast. Kevin here, and I'm joined once again by Mike Kelly, the head of the Criminal Defense Department at Kelly and Kelly PC. Thanks for joining us again, Mike.
Good to be back. We got some new things to talk about here. Specifically today, we're going to be talking about changes regarding marijuana.
Yep, the ever-developing complex area of Michigan marijuana laws. So what is the big change? People v. Hess, Michigan Supreme Court ruling. Let's hear your legal take on this.
Yeah, so this is a huge deal. It came out July 6th of 2026. People versus Hess. This is a case that started in our district courts. A common scenario that a lot of criminal defense practitioners have run into for many years, where you had somebody in this case, Ms. Hess, who was convicted of retail fraud for shoplifting at a Myers. And when she went through her sentencing, as a part of her sentence, the judge had made a prohibition against any use of marijuana, along with many other things. Now, in this case, what was interesting about it is that the underlying crime of retail fraud was not a specific substance use, abuse, or a controlled substance offense in itself. And in fact, there wasn't any information provided from the underlying incident itself to suggest that there was any correlation between marijuana and the criminal behavior that Ms. Hess pled guilty and was found guilty of committing. So this case went all the way up to the Supreme Court when Ms. Hess had a series of probation violations. Her attorney ultimately challenged the second violation, saying, hey, listen, MRTMA, which we know is the Michigan Regulation Taxation of Marijuana Act in Michigan, protects lawful marijuana use. And therefore, you can't violate Ms. Hess as a condition of her probation because MRTMA preempts the federal prohibition against marijuana. As a standard condition of probation, they simply said not to violate any laws of this state or the federal government. And because marijuana had still been a crime at a federal level, they found that her use while she was on probation could be treated as a violation of probation. But in this case, the Supreme Court ultimately disagreed with the lower court's interpretation and said, hold on here. No, unless there's some specific correlation, some causal connection between the offense which the person is convicted of and the prohibition and the use of marijuana, you can't just arbitrarily say it should be precluded because it would be a crime under federal law. So in this case, the Supreme Court found that MRTMA, Michigan's Regulation Taxation of Marijuana Act, did in fact preempt federal law. And without any further justification by the court, they couldn't just say, the district court could not just say that if it's a crime under federal law, we can prohibit you from using it under our state law, probation laws.
Oh, interesting. So if it's not related to marijuana or marijuana wasn't used in some way in the offense, then they can't necessarily prohibit you from recreationally using marijuana. Am I understanding that correctly?
Right. They still have to show some connection, what I call a rational basis. They still have to connect the behavior prohibited and the offense that was committed. So in cases you say like a drunk driving case, well, alcohol, even though it's legal, you can be prohibited from using alcohol while you're on a DUI, a drunk driving probation, because there's a connection between the two. But it wouldn't make sense as the court rationed in Ms. Hess' case that something was of a non-drug or alcohol quality for them to then say, well, we don't want you engaging in this behavior anyways. And there wasn't a connection between shoplifting and marijuana use.
Okay, that makes sense. So not everyone can use marijuana on probation.
Well, no, and let's be clear, this is not opening things up to say, ha, 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 the judge can't order me to stop using marijuana. I had a criminal case with sentencing the day after this opinion came out. And it was almost like the judge didn't bat a lash with the People versus Hess opinion. He didn't all of a sudden say, oh, hold on here, let me change this connection. In the case that I had, even though there wasn't a direct per se connection between marijuana possession or use and the charge that they were being sentenced for. In this case, it was a an operating while intoxicated charge. They weren't operating under the influence of marijuana, but the judge still found a causal connection because on a DUI type of case, the court does conduct a substance use screening to identify any potential pitfalls, any potential tendencies for this person to have a substance abuse issue. And in that case, the judge could still order a ban against the use of marijuana because the person did identify as having a substance abuse issue. So if the judge can make a connection between banning marijuana and the offense that they're sentencing you on, they can still continue with banning that marijuana use. But they have to show their work. They have to show some rationalization between the two. They can't just make a blanketed statement that you're not to use marijuana because it would be barred or banned under federal law. They cannot say that in a blanketed statement. But at the same time, we got to understand here, alcohol, like I mentioned, is still legal, right? You can lawfully consume alcohol if you're over 20, if you're 21 years of age or older, but the court can ban you from using it if there's a connection, if there's an identified substance use issue, or if the substance was related in the underlying offense itself. The same goes for marijuana. If there's a substance use disorder or diagnoses that addresses a concern that somebody may have a tendency to abuse or overly use a certain substance, then the judge can still ban that as a condition of your probation.
Okay, that makes sense. And now, what about people who are already on probation that their probation was enforced before this ruling? Are they
Well,
grandfathered in?
right. And I think you obviously need to talk with a lawyer about, do my circumstances fit that? Now, if you're somebody like Miss Hess, who had a charge that didn't have anything to do with marijuana, and yet you're being subjected to marijuana drug testing, well, yeah, I think you have a good question there to ask an attorney. Is this something that I could pursue modifying the terms of my probation to eliminate that requirement for testing? But if this was a case where you're on it for, like I say, a drinking and driving offense, but you want to be able to use recreational marijuana, while you're still on probation, you may have a tougher time, because in that situation, Michigan law would require the court to have a substance abuse screening completed prior to sentencing. And in that substance abuse screening, if there's any substance abuse issues that were identified, the court may be able to justify the continued prohibition against recreational marijuana use.
Got it. How are you seeing this affect current cases, and how do you anticipate it will affect future cases?
I think marijuana across the board is rapidly changing in the eyes of judges, prosecutors, probation officers, and police officers in the state of Michigan and across the country. Long and gone are the days where the simple smell or suspicion of it really gives rise to there must be criminal activity afoot. I think now everybody needs to look at it through a different lens, that this could be protected, legal, lawful, reasonable use of a substance, just like alcohol, that as long as it's not being done or consumed or used in a way that promotes somebody to commit a crime, I think the court needs to be a little bit cautious about making blanketed assumptions about just simple use, or the fact that somebody has used in the past or is currently using. They have to look at through a lens of, well, is it medical? Is it recreational? Is it being used properly under MRTMA? Is it being used properly under the medical marijuana laws? And now they have to look through a different additional lens of, is there a connection between the underlying offense and the use of marijuana, or the precluded use of marijuana as a condition of probation?
It's more nuanced, I can see. Let's add another layer of complexity, Mike. What about medicinal marijuana?
Right. We still have the Michigan, the Medical Marijuana Act is still valid and still is the law of the land in terms of protected use of marijuana. I would still recommend clients that have a qualified right to use, have a qualifying condition. They need to make sure they're properly it's properly credentialed and documented. The courts are not going to ban you or really challenge you as much as they used to on your qualified right to use. That is still the best case scenario for somebody who believes that they need to use marijuana to address a clear diagnosed medical condition. And it is definitely a hands-off area for the court if you're able to show that you're protected under the act.
Got it. And what are some final advice pieces of somebody on probation? Like, it wouldn't be just you. I'm sure you wouldn't advise just to start using marijuana because of this ruling. It's probably ideal to talk to an attorney if you're on probation before.
Right. And right now courts are making clear that you must, even if it's like if right now, if you go out and get like a medical marijuana card, you have to get the court's approval before you begin to use that. So if you're watching this video or you read the Hess opinion and you're saying, hey man, I just saw this, or maybe you read half of an article about it and you think that this means that the judge can't order you to stop using marijuana, you're wrong. You're wrong. And quite frankly, the judge can still do a lot of things, whether or not the information out there or legal opinions may disagree. You still have to cross that with the judge. And it's certainly not worth you being in a position where you're in standing violation of a judge's order because you maybe you misinterpreted what your rights were. So I think you absolutely need to consult with an attorney and say, hey, am I one of those cases like Ms. Hess, where I'm brought in for retail fraud and I'm being ordered to stop using marijuana? That would be a very good example of somebody who probably would be able to petition the court and say, hey, there's no relation here. But if you were different from Ms. Hess, let's say you had a prior marijuana charge or a prior substance use disorder, or they did screen you as part of your intake with probation and they identified you as having a substance use disorder or having a past substance use disorder, then they may be more protected in saying, yes, there is a connection between the two. Don't go at it on your own. Don't make assumptions and don't take any chances that might lead to you ending up in jail and not being able to navigate this the best way possible. Call an attorney, call me. Let's get to the bottom of it and figure out, are you a case that should be reviewed based on the new information that's come out from the Michigan Supreme Court? And if yes, what are the next steps that we can do about it? We can file a motion, we can notify the judge, and we can modify that probation order so you can be protected and not run the risk of having something come up and being in violation of your probation term.
It's certainly not worth the risk to lead to more serious charges and potential jail time. I think that's sound advice, Mike.
Absolutely.
Thank you for your legal perspective and your time.
All right, everybody stay safe. And as always, call Kelly.
Until next time, bye.